Good morning, everybody. I know there's a few more people that are going to be attending, so if you don't mind, just wait another minute or two. Allow those to log in. Thank you. Okay, to respect everybody's time and get the meeting kind of off on the correct schedule, why don't we go ahead and start? I'd like to welcome everybody to the Police Response to Crimes of Family Violence Model Policy Subcommittee. Today we're going to be reviewing the recommended changes to the model policy made by the members of this subcommittee. And with that, if we could go ahead and just introduce ourselves, where you're from, and Chief Fox, if you don't mind starting.
Alaric Fox, Enfield Police Department. It's good to see everyone.
Thank you. My name is Dan Cargill. I'm the Director of Law Enforcement Services at the Connecticut Coalition Against Domestic Violence and retired from the state police. Gail?
Good morning, everyone. Gail Hardy, and I am the Chief State's Attorney's designee to this group.
Mary?
Good morning, everybody. Merritt LaJoy, Complaint Officer for the Office of the Victim Advocate.
Thank you. Sean?
Morning, everyone. I'm Shauna Harrington. I'm the Director of Criminal Legal Advocacy here at Connecticut Coalition Against Domestic Violence.
Thank you. Chief Rosado?
Good morning, Rob Rosado, Chief Police in Meriden.
Trooper Richmond? Dan? Can you hear us? Andrea?
Good morning, everyone. Andrea O'Connor from the Umbrella Center for Domestic Violence Services. I am the Family Violence Victim Advocate Program Manager, which is the court-based victim advocacy services.
Thank you. And Lieutenant Maynard?
Good morning, Lieutenant Maynard, Connecticut State Police, Commanding Officer of the Training Academy.
Thank you. Okay, following our agenda, selecting two chairpersons.
Good morning, Gail Hardy, again with the Division of Criminal Justice. I move and nominate Dan Cargill and Chief Alaric Fox as co-chairs of the Model Policy Subcommittee In support of this motion, I would point out that each nominee has extensive law enforcement experience. Each comes to this committee with decades of experience, either from municipal police departments or the state police law enforcement ranks. Each nominee has also demonstrated commitment to training law enforcement officers through the post-council academies and providing training in the field to law enforcement and other persons who work in the area of domestic violence. I think that they are each best suited to co-chair the model policy subcommittee. So
I second the motion. Merritt LaJoy.
Thank you very much. And is there any discussion, or would anybody like to discuss this? Okay, I certainly appreciate that, and I would certainly accept that nomination. Chief Fox?
I thank you, Gail, very much for the kind words. It is appreciated. Thank you.
And I think we can call for a vote. We had a second by Merritt. Any abstentions? Okay, all in favor?
Aye.
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 Thank you very much. It's our pleasure to present to you the recommended changes. These changes were sent out to everybody via email. I appreciate everybody's feedback on some of the recommendations, and we can have some discussion here today and take a look at those recommendations. So I'm going to go ahead and share my screen. Okay, everybody's able to see the screen? Excellent. So there are some administrative changes that you'll see in here, and then there's some substantive changes, and we'll have some discussion on some of the most recent recommended changes to the policy. So the very first page, we'll just notice the new cover page has the correct date of January 2024. The dates have all been changed, so that's an administrative change. And then some of the page numbers had to be changed because some of the additional content or updated content. Now, from a historical perspective of the model policy, this was created back, I believe it was 2012 through a public act, which was actually enacted in 2013, where the subcommittee came, or rather a committee came together and developed law enforcement or police response to family violence or crimes of family violence model policy. This has been updated and adopted year after year through the Police Officer Standard and Training Council. And that's the basic history of this. And the forward and policy purpose, I don't think has changed much over the years. I still think the statements still hold true for in the forward as well as in the policy purpose. And no recommended changes in that section. You'll notice there are a few changes. They're indicated by the gray bar. Those are either links that had been broken or needed to be updated. So Connecticut General Statute 53A-24 needed to be relinked. And as public acts fall out in terms of 2018, it's now been fully incorporated into statute. It's found if you searched the 46B 38A and went to section or subsection 5, you would find the language that was incorporated in 2018 by Public Act 18-5. So I start removing those public acts because we have those references now plainly in the statute. So for one of the first changes to actually some of the content is typing out the orders of protection rather than using the short OOP. If everybody's in agreement with that, we can move forward with that. And then the addition of whether children are present or involved, because law enforcement now provides the victim with resources on mental health in the area that victim resides in. I thought it was important that we use the terms present or involved, or added that present terminology, just because we want to reinforce the fact that if they are present, there's another step that has to be taken. Makes sense. Some of these changes are just simply taking up spaces or removing some spaces to get everything aligned again as updates are being made. And again, Public Act 18-5, you'll see this numerous times throughout the document where it's been removed because, again, 46B38A subsection B is fully incorporated with the language from Public Act 18-5. This link has been updated, and that's why it's highlighted as a change. The old link just went to the Post webpage. Post, or the state, has updated the links to Post website. So I wanted to make sure that you clicked on that link, it went directly to the document, so you wouldn't have to navigate through the updated Post website to find the link or find the actual document. Any questions on that? And that was a 2010 update. That's why it's so far in the rears of their publications. So this is an update that was recommended to better clarify when domestic violence incidents and orders of protection is violated. Because violations of orders of protection are considered domestic violence or family violence, adding the language rather than keeping in the or. So it read in the past like this: it is highly recommended that in domestic violence incidents or investigations of orders of protection violations, that gives it the or gives it the denotion that it might be a separate incident or a separate crime, not a family violence crime. So the added language of which includes now reads, it is highly recommended that in domestic violence incidents, which includes investigations of orders of protection violations. So again, it's just a little bit more of a clarity issue. Wanted to make sure that we are illustrating that violations of orders of protection are family violence. Any questions on that? Public Act 19-189 was removed, and it's fully incorporated in the statute. This is a most recent recommended change, and the recommended change is adding or replacing the speedy information or upon speedy information, and replacing that with probable cause. So the statement would be, whenever an officer determines probable cause that a family violence crime, as defined in Connecticut General Statute 46B38A subsection 3, has been committed, rather than whether an officer determines upon speedy information. I think it's an interesting change, an interesting clarification that we're talking about specifically probable cause being developed. And I'd like to open that up for discussion because this is one change that hadn't been sent out previously.
What prompts this? Was that's not a statutory change. That's just something that, forgive me for how this sounds, that you offered or that you suggested?
One of the council member, or one of the council members made that suggestion.
What do we see? What do you see as the? Because there are going to be instances where we have probable cause, but the probable cause isn't flowing from a speedy No, I'm gonna retract that.
And I reviewed 46B38A, and it doesn't have anything specific around speedy information.
I could just touch on that. That's my suggestion. And we arrest based on probable cause, not the information. And within the statute, it gives you the right to either go by warrant or do it, by speedy information, make an arrest on site arrest, or go by warrant. So I think this is just cleans it up a little bit. The actual statute allows you to go either way, as long as you make an arrest.
Okay, Chief Rosado, your speaker is cutting off. I don't know if anybody else can hear that.
It's a little bit, Rob, it's a little choppy. It's like a bad signal or short or something. Just so you're aware, I got like every other word. About the same.
I'll type in.
So, I mean, the more I contemplate it, it seems like the practical difference is that this language is now saying anytime you're a PC, even if you didn't get there the speedy information route, if you got there one of the other routes, that the ensuing arrest action is gonna be taken. That's the practical difference, right?
Correct. That's how I see it.
And Chief, it does specify further down in the arrest guidelines, it does actually get into the custodial arrest, whether it's summons, warrant, or the speedy information. So I think this just kind of leaves it a little more broad in the sense of if probable cause, like the arrest will take place, and then it specifies further in the policy as to how you're actually going to make that arrest, whether it's on the speedy or whether you're doing by warrant.
Okay, that is helpful. I guess what I was wrestling with originally is a situation where I've got probable cause, but for whatever reason, and it could be input from a prosecutor, as unlikely as it would be that they would discourage an immediate speedy arrest and prefer a warrant in a domestic violence situation. There is the possibility in a given case where that might be, for whatever reason, preferred. But the way you're describing it, oh, and I see what you're saying, yes, it does continue to give you the options later on down as to how you're going to do it. Okay, I'm good with it.
Any other discussion, comments?
I'm now reading Chief Rosado's comment and his chat. Thanks, Chief. That makes sense to me. Doesn't sound like there's any objections, Dan.
We're okay with that? Okay. I will make that change in the document and send this out, obviously, before we do anything further, but we'll make that change. We'll replace probable cause or the upon speedy information rather with probable cause.
But Dan, and just to shore it up, the point that Lieutenant Maynard just made, I thought was very well made, and it's 1, 2, 3, 4, 5, 6, 7, the 8th bullet down. You don't think that first change, the 8th bullet is still accurate as it's written, correct? I mean, I want you to say yes. It makes me have a comfort level with the change we're talking about in the first bullet.
Yep. Just getting through all of the material. Yeah, that's accurate. I think it covers all of gives all the guidance that one would need.
All good.
Okay. Any other comments, questions?
And Chief Fox, the only other pieces we will get to it, but under page 11 under jurisdiction, it does actually spell out the misdemeanor felony, and that's where speedy is specifically spelled out as well as to what's going to be required or not.
Perfect. Thank you.
Okay, here's a section where Public Act 18-5 has just been removed in each one of those sections. Right, this is another change or another recommendation that was just given recently, so I want to review this with all of you. So this is specifically around internal affairs investigations, and the way this is reading, it is suggesting that if they have an internal affairs unit within the department, that it will be an investigation will ensue after the criminal investigation. However, it just ends there. It doesn't give any further guidance or recommendation that if they don't have an internal affairs unit within the department, that a subsequent outside agency or independent investigation should be or will be conducted. So the language here is take out that entire sentence, that entire bullet, or make it clearer that an internal investigation will be completed internally or by an outside independent agency.
And how many, did I just hear you say that some departments don't have an internal investigation? I mean, internal affairs division?
Correct. There are many departments that are small 20-person agencies. So yeah, there's a number that don't.
An example, so for example, like this, the constabulary towns from the state police, if they rely on the infrastructure of the Connecticut State Police, they may not have an internal affairs, but Connecticut State Police IA would actually carry out the internal affairs for that organization.
Right, so is there any municipal department outside, you know, not a constable, not a resident trooper, any municipal that doesn't have an internal affairs office?
Most do not. I have 100-person department, large department. We do not have a dedicated internal affairs unit, which is, I think, what Dan's concern here is. We would do an internal affairs investigation, but I don't have such a dedicated unit by name, by title. I think what we achieve is sought if you simply put a period after the word criminal investigation. I'm sorry, I didn't mean to cut you off. I think it sounded like you had a follow-up question.
I guess my follow-up question is, so where, for somebody to complain about the actions of a law enforcement department without an internal affairs office, what does a person do?
They complain to anybody within the agency. It gets assigned to a supervisor within the agency. The agency simply isn't large enough to have a dedicated internal affairs unit. It would go to an agency supervisor for investigation. In Connecticut municipal PDs, I suspect you're probably only talking about Hartford, New Haven, Bridgeport that might have their own standalone units. It would be like like Hartford PD probably has a stolen car unit. I do not in Enfield. Meriden probably does not. So the complaint still gets taken and it still gets assigned to an internal affairs investigator, but they're not full-time in an internal affairs unit.
Got it. Thanks for the clarification.
Pleasure. And Dan, however you want to wordsmith it, but I think that what you're describing is your concern, rightly, with the phrase, if such a division exists within the law enforcement agency, because that implies that the IA doesn't have to be done if such unit doesn't exist, which is what we just talked about. We know it still has to be done. So you achieve what you're looking for if you just cut those last 7 or 8 words. 10 words.
I agree. So that sentence would read, an internal affairs investigation will be conducted during or upon the conclusion of the criminal investigation, period. And that leaves the door open for internal agencies, external agency, the state police. Any more discussion or questions on that? I'll make that change. So this is the Domestic Violence Alert Notification GPS program. If you're at the November meeting, Director Joe DeTuno provided an outline and update on the GPS program, and Public Act 23-106 that expands that program, and the steps that have already been taken are illustrated in this change here. So now we've added Derby and Milford courts, and then we laid out the expansion that is planned for the fiscal year of 2024 with Waterbury, New Haven, Torrington, Danbury. And then in 2025 fiscal year and 2026 fiscal year, additional courts will be noted or identified. And then the other piece that they changed, and these changes are recommended directly from Director Joe DeTuno. And he added one other line: that a protected person may also elect to fully participate in a 2,500-foot restricted area will be around that individual, creating a mobile zone. Any questions, comments? We're okay with that change? We're going down to the criminal possession of a firearm. There had been a number of changes, and one of those was in 2022, which we removed a section. But this is all statutory updates, specifically around who can possess a firearm and who cannot. And the large portion of the additions are around the mental health aspect in individuals who have voluntarily or been committed to a hospital for persons with psychiatric disabilities, and the requirements that they cannot possess firearms in the future or ammunition. And it does have that one carve out in the language, unless that individual went into that hospital for drug or alcohol treatment. So this is strictly legislative language from the updates. Any question on that?
Looks good.
And that's specifically around, and I just added, just from a technical aspect, I added the statutes that are linkable right at the very top, because I wanted to show the criminal possession of a firearm, or at least those links right there at the beginning, because it's we didn't get into a paragraph describing anything. We just went directly into the circumstances. So that was just added just as a little denoter. The and/or electronic defense weapons was added down here in this smaller section. And again, that's straight out of the statute. So the risk protection order warrant section, which is further down here, there was a new process. So this process is no longer applicable. And what I did is, because the risk protection order process is very large, in fact, we would use up most of this document just describing the nuances of risk protection orders or warrants, that I tried to keep it simplified and specific, that officers may consider utilizing the risk protection order warrant or the order as it relates to family violence when these conditions are present. Any questions on that? Tried to keep that a little more concise just because of the volume, or the circumstances can vary so greatly.
Otherwise, you would have doubled the size of the document, and we would have been chasing changes that are inevitable in perpetuity.
Any questions? In the federal domestic violence laws, I went into each one of the titles. Reading through all of the language, there were a few pieces missing. I'm not sure why sexual violence wasn't in there originally when this section was either added to or maybe changed. And frankly, I wasn't able to find when sexual violence was either added to the federal statute. So I just added that there. It is part of the actual language. Questions on that? And the rest of this is, again, right out of the statute. Added the word kill under Title 18, 2261 A1. Again, that's directly out of the language. And the other piece they had in there is the or dating partner. So they differentiate between intimate partner and or a dating partner. In Connecticut statute, we don't do that. They're all as one, but for whatever reason they do in the federal statute. So I just wanted to make sure that we were clear and consistent with what their language specifically was. Any questions on that? And I will just mention that the intentionally commits violent crime or causes a bodily injury, that was not part of the language. So I struck that from this document. I'm not sure where it was in the language previously. Again, it didn't have the notation of when that was updated, but that's been removed in both of these sections. Any questions on that? Okay. And again, for the internet, interstate stalking. Again, just a language straight out of the statute. And part of that is the person's immediate family. And then they also had added in the pets, service animals, and the emotional support animals, or the horse of that person. And that had been added in not too long ago as well. And the next two sections or the next two additions are directly out of the interstate violation of protective order, directly out of that language, because all consistent. Any questions on that? The comparison of orders was all updated last year. So there were no changes to any of this section.
And there was a reference at the top of this to updated to 2020. Do you want to make that to 2024 if we have that confidence level right there?
Yes, I can do that.
I'm just kind of showing off that we're on top of it and keeping it up to snuff.
Yeah, absolutely. Any further questions? We're at the end of our document.
Well done. That's the heavy lift.
Well, I appreciate everybody who contributed and went through the document with a fine-tooth comb. There's some what I call administrative changes, which are, adding the comma that hadn't been there before just because of punctuation. Doesn't change any of the meaning, doesn't change any of the description of the statement. So a few of those in there, we caught one misspelled word in there as well. So that was great as well. I appreciate that. Any further questions? Chief, you just unmuted. Do you have something?
No, do we need a motion to accept the changes?
Correct. So the next step, if there's no further discussion, we'd need a motion to present the recommended model policy changes to the full council on the January 31st meeting.
I'll make that motion.
Chief, I think you were making that motion to present the changes to the council on the 31st.
I second it.
Gail, thank you very much for seconding it. Any abstentions from any discussion? All in favor? Aye.
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 Okay, any opposed? All right. Okay, thank you. We'll move this document to the full council on the 31st for their review and final approval. From there, this document will then be delivered to the Police Officer Standard and Training Council for publication on their website and then sent out to chiefs across the state for incorporation within their independent or their individual policies with their department. All right. Thank you very much. Anybody have any other further business? All right.
Dan, is the meeting on the 31st in person?
Correct. That's in person at the LOB. You'll be receiving an announcement from Jerry O'Neill Wild, and she'll be notifying. I will be away. That's why the email will not be coming from me, unfortunately. But yeah, you'll find that email again with the agenda and the location, the room location at the LOB. All right. Would somebody like to make a motion to adjourn?
So moved.
So moved.
All right. Thank you very much, everybody. I appreciate all your hard work and efforts on this, and we'll see you in the meeting on the 31st.
Thank you.